This is part 2 of a video where we will be discussing the different steps of the trial process in a criminal law case. This video was prepared with the assistance of PBSC University of Manitoba law student volunteers. PBSC volunteers are not lawyers and they are not authorized to provide legal advice. This video contains general discussion of certain legal and related issues only. If you require legal advice, please consult with a lawyer. In the first video, we discussed what an arraignment and plea are, what an opening statement is, and how witnesses are called. In this video, we will be discussing when objections are called, what a voir dire is, what's a closing statement, and lastly, sentencing. Throughout the direct examinations, cross-examinations, and re-examinations, there may be objections called by the Crown Attorney or defense. An objection may be called when a witness is being asked a question that is leading, irrelevant, overly aggressive, prejudiced, argumentative, or vague. This is not an exhaustive list of all the instances an objection may be called. After an objection is called, the judge will then decide whether the objection is valid and will provide instructions to the jury if they are present. Throughout the presentation of evidence, a voir dire may be called by the judge during a criminal trial with jury. A voir dire pauses the main trial and functions as a mini-trial to allow for technical arguments to be made. This is done to determine whether evidence can be used. Witnesses and jury are not present during a voir dire, so they remain impartial. After the Crown Attorney and defense have presented all their evidence, they provide their final statements to summarize their case. Once the judge or jury have taken consideration of the case presented by each side, the accused will be ruled as guilty, not guilty, or there will be a hung jury. If the accused is found guilty, the judge may provide a sentence immediately or on a later date. A sentence is the penalty or punishment issued for the crime they are charged with. If the accused is found to be not guilty, they are free and cannot be tried again on the same charge unless the Crown appeals. A hung jury occurs when the jury is unable to reach a unanimous decision. When there is a hung jury, the judge may order a new trial with or without jury. If the accused is found guilty after the trial, the judge will consider the cases submitted by both sides and decide on a sentence. The Crown Attorney and defense may make sentencing recommendations, but the final decision is made by the judge. If the Crown Attorney or defense are dissatisfied with the verdict or sentence made by the judge, they can file an appeal and a new trial may be ordered. An appeal is a request for a higher court to review the decision of a lower court. If you require more information about appeals, please visit our Introduction to the Legal System video. This brings us to the end of part 2 of our video about criminal law trials. If you require more information, please visit the following web pages. Thank you for watching.